So today we're going to be discussing a recent case called Birnie and Birnie. It's a 2019 decision of the Ontario Superior Court of Justice, and it interestingly deals with the issue of life insurance proceeds, which seems to crop up fairly recently, and we were in the Supreme Court of Canada not so long ago on that very issue.
Right. And, especially with the way life insurance policies are used to secure family law obligations, there are so many, marital breakdowns, second marriages, third marriages, and, sometimes things are not as clear as people would like it to be, and then there's litigation afterwards. It's always hard to predict, who you might be with at the end of the day, what kind of dependents you might have, and so that's the exact fact scenario that we have in this Birnie and Birnie case.
Right, it seems to be a fact scenario that I feel is repeating, where we have a husband-wife who divorced, and as part of their separation agreement, the husband agreed to take out a life insurance policy in the amount of $500,000 in favor of the former spouse.
Right.
And then, surprise, surprise, he doesn't do that. So we fast forward, I don't know how many years.
I think it was about maybe another 15 years later.
Right. And he passes away.
He passes away from cancer. He died, I think, fairly young. He was in his 60s. He was married to his second wife.
Right.
She has a child as well. Second wife is the estate trustee of his estate naturally.
And even that was a lengthy marriage, right?
Yeah. They were together 15 years, and then he was together for 15 years with the first spouse as well.
Right.
So, this file started with the issue of what is that first spouse entitled to now that he's gone, and whether or not it's just a continuation of those monthly payments, or she gets her $500,000. At the end of the day, the policy wasn't there.
Right.
So,
and you bring me to a good point, because in their separation agreement, he also had to pay her around $6,000 a month, and then there was also a requirement to, I guess, pay cost of life increases if requested. And so not long before he passed, there was a communication from his former spouse to him seeking, or at least I think complaining that he hadn't gone out and gotten life, and she wanted that confirmation that he got the policy, and she had wanted an increase, right?
Then, it wasn't too long after that he died, a couple of years later, so she never really did get that confirmation, but at the end of the day, there was enough money left in the estate that there was at least $500,000, and then the court had to decide, well, who does this $500,000 belong to? Does it belong to the estate but to be paid to the first wife, or is it up to the beneficiaries of the estate to have?
Right, and the argument on both sides, as I understand it, is the former spouse is saying, well, our separation agreement says he has to take out this policy, and I see that as it was a standalone clause that an obligation he had to meet, regardless of anything else in the agreement. Whereas the new spouse / executor argues that, well, no, that obligation was really just supposed to be security for the monthly payments that he was going to be making. So it's really just a security mechanism, and it's not truly owed. Right. So that's what the court had to wrestle with.
Yeah. And at the end of the day, the court found that it was a standalone obligation. The agreement didn't have anything that explicitly stated that it was purely for security. So the first spouse gets the $500,000 from the estate, no questions asked. Plus, they were asked to come back and make submissions on her cost of living adjustment requests.
Right. And it's interesting because when you look at the actual language of the separation agreement, there is a suggestion. I don't have the exact language in front of me, but there is a suggestion. It seems implied that it might be for security, but it's just not, inked.
It didn't say solely for security. I think it's to secure, and it falls under all the provision, the heading of the spousal support, which was the second spouse's argument. But because of a 2009 decision called Turner and Di Donato, subject to that express language, that it's solely for security, it became contractually interpreted as the alternative fallback, which is just a standalone clause, and you know.
And notably, that case is several years following the agreement that they entered into. So, you know, perhaps it's just an unfortunate matter of timing. But there was no other evidence as to what the intention was at the time of the separation, and particularly from the part of the deceased. You know, I think they could look at surrounding circumstances, but we couldn't gather from the decision that there was any other material evidence that the court could rely on. So I guess the absence of that clear language really ruled the day.
Right. And so I guess it's always good to bring things back to like the specifics of like sort of some of the estate statutes that we're dealing with as well when we're talking about something like this. Part of the second wife's argument was that, like, okay, I understand that my late husband has these obligations to his first wife, but both myself and my son have our own competing dependent support claims under Part 5 of the SLRA.
Right.
And Part 5 of the SLRA lets you claw back certain assets that may have flowed outside of the estate to somebody else for the benefit of dependents like herself, and that's commonly known as the Section 72 clawback.
Right.
However, people who have, you know, separation agreements or court orders indicating that you are a support recipient, you might actually fall under the category of a creditor of the estate, and Section 72 does not affect the rights of creditors, which is why we fell into the analysis of whether or not that policy was just solely for security. Because if it's solely for security, then parts of it would be still subject to that Section 72 clawback. You know, the amount of debt might be less than the $500,000, or it's just a standalone clause.
So I guess, you know, it seems to me, I don't have really any criticism of the court's decision. In my mind, it's always a very tough scenario when you've got two, frankly, innocent parties who are in the unfortunate scenario having to battle over limited funds. But at least in this case, there were sufficient funds to make that payment. I recall the estate was not as large as it had hoped to be. So I don't know that there was a lot more to help provide for the current wife and son.
Right.
But the $500,000 had been paid into court during the dispute, so they were secured, and at least we don't have a scenario where there's insufficient monies and it's even more dire. So even more victims. So yeah, so it's an interesting reading. We are you know, because Ian Hull and David Smith and Susanna Montag did go to the Supreme Court of Canada on, you know, this kind of issue. It is really of particular interest to us when we see these cases arising. So we're happy to discuss them. Okay, and unless you have any other comments, I think that ends our podcast today.
Thanks, Natalia.
So until next time, we want to thank you for listening and watching. I'm Natalia Angelini.
And I'm Doreen. So,
should you have any questions, please email us at webmaster@hullandhull.com or leave a comment on our blog.
thanks.